the creation of a contract of agency. How is it actually created? We're able to see the duties and rights of the parties, rights of the parties under an agency contract, under an agency contract.
Excuse me, William.
Yes.
Your mic is, I think, is very far.
The mic is very low.
Yep.
So what about right now? Is the mic okay?
Yeah, very much okay.
I think now it should actually be okay. So I think it was a bit far from me. So you're saying we're going to be able to look at the rights and duties of the parties. Then we'll also be able to see the termination, how the contract of agency actually comes to an end. So termination of a contract of agency, termination of a contract of agency. So what do we mean by a contract of agency? So in this kind of a contract, it is whereby someone else actually performs a duty on behalf of another party. So we have one of the parties under the contract being given a role or a duty to perform on behalf of another party. So maybe the best example you can be able to give is, for example, an Mpesa agent and Safaricom as a company. So the Mpesa agent actually carries out a role with regard to do with maybe depositing and withdrawal transactions for Mpesa on behalf of Safaricom as a company. We can be able to use another example, a salesperson or a sales agent for a company. So the sales agent basically is given products by the company, it could be a manufacturing company, to be able to sell on behalf of the company, So in short, what we mean, or basically what we mean by a contract of agency, it is simply where a person known as an agent, so it is where a person known as an agent is employed, it is where a person known as an agent is employed by another person known as a principal to carry out a task on behalf of this person we are calling the principal. So we can be able to say an agency contract is where is a contract where it is a contract where a person known as an agent, it is where a person known as an agent is employed or tasked, or tasked to perform an act, on behalf, perform an act or a duty, to perform an act or a duty, to represent another, in dealings with third parties, So the party represented is known as the principal. The party the party being represented, the party being represented is known as the principal, So the party that is being represented will actually be termed as being the principal. So now in this case, we can be able to say that Safaricom as a company is the principal, while the Mpesa agent is now the agent in that case. So Safaricom as a company is the principal, while the Mpesa agent is now the agent in that case, because the Mpesa agent is representing Safaricom with dealings of customers on behalf of Safaricom as a company, So this particular person we are calling the principal ideally authorizes or gives the mandate to the agent to be able to carry out this particular tasks. So you can be able to see the characteristics are basically coming out from the definition. So it is simply where in a contract of agency, it is simply where a person known as an agent performs a task on behalf of another person known as the principal. And of course, in this case, what we mean by this is that the agent is actually representing. So that is another characteristic you need to note, that the agent is actually representing the principal. So he's basically acting on behalf of the principal. So another key thing to be able to know is that all the acts of the agent will basically affect the legal position of the principal. Or basically what we mean by this, the principal will actually be held responsible for all the acts or those particular duties or acts that are actually done by the agent. So for example, in this case, if that Mpesa agent actually does an error or a mistake, so the person to be blamed ideally is the principal, or basically Safaricom as a company. If the sales agent who is selling products on behalf of the manufacturing company basically makes an error or delivers a product which is not actually okay, the person to be held responsible, for example, in a court of law, will be the manufacturing company for having sold out or given out products which are not actually best for consumption. So all the acts, so that is very key, that all the acts of the agent will basically make the principal become responsible, because in this case, all those duties were being carried out under the authorization or under the supervision or under the instructions of the principal. So the acts of the agent will actually affect the legal position of the principal. So those are the characteristics of contract of agency. So we can look at the creation. How is it actually created? So creation of contract of agency. So number one, how it can be created? It can be created through what we call an agreement. So just through an agreement. Number two, it can be created through what we call ratification. Through ratification. Number three, it can be created through what we call the doctrine of estoppel, through the doctrine of estoppel. Through the doctrine of estoppel. Number four, it can be created through what we call out of necessity. Out of necessity. Number five, it can be created through what we call presumption or by cohabitation. By cohabitation. By cohabitation. So maybe I'll go through them very quickly, then we see how we'll be able to approach them so that you understand them properly. So what we mean by agreement, through agreement, creating an agency through agreement, is basically just formally coming into an agreement between the agent and the principal. For example, it could be either be in writing or maybe orally. So it basically arises whereby the two parties mutually agree on the terms under the contract that one of them will actually act as an agent while the other one basically will act as the principal. For example, in this case, probably if you want to become an Mpesa agent, then probably you could get a form from Safaricom as a company. You fill it out. Once you fill that particular form out, so Safaricom can either agree to your proposal or basically agree to that particular contract that you become an agent for Safaricom. So formally, you can enter into an agreement. Through an agreement, you can be able to create what we call a contract of agency. So an agreement just crafted, creating the terms and the conditions that's supposed to prevail under the arrangement between the two parties. So that is the agent and the principal. So through an agreement, the contract of agency can be created. And then number two, we are saying by ratification. What do you mean by ratification? It is simply where, for example, a person can be able to carry out a task on behalf of another party while that particular party is not actually around or not available. Then eventually, when the party is actually now available, basically what he does, he ratifies or actually approves. So an example you can be able to use is, for example, if you work under your manager or maybe your boss, so there could be a day this particular boss of yours is not actually in office, so he has left all the duties of mandates for you to be able to carry out. But maybe there's a certain task which he had not actually ideally given you the direct mandate to be able to undertake. But while he's actually away, you are able to fulfill that particular task on his behalf. He hasn't given you the authority, but you just feel that you can be able to perform the task on his behalf. So you carry out that particular act or duty on behalf of your boss or basically your manager. And then once he's actually back in the office, he actually simply approves what you had done. He simply ratifies what you had done. So this contract basically will only arise after the ratification. So once he ratifies is when now the contract will basically have been created. So simply it's basically ratifying or approving an act you did on his behalf while actually away. So through ratification, now you are manager and you as a person, as the employee, you become now like an agent, while your manager now becomes like the principal. The agency is only created when now the ratification has been done, the approval has been done. Let's say, for example, if he fails to approve it, then the agency cannot actually arise. It cannot actually basically arise. So that's what we mean by agency by ratification, simply where a person carries out a task on behalf of another party while away. Then when this party is actually available, he simply actually approves or basically authorizes what had been done on his behalf while actually away. Then we have through the doctrine of estoppel. So what we mean by creation of agency by estoppel, it is whereby if you look at how a person basically is conducting or carrying out himself, it can basically be presumed that this particular person is actually carrying out a mandate on behalf of another party. So also, according to how the principal conducts himself. So according to how the principal in that case conducts himself, it can basically be presumed that an agency has been created. Let's say, for example, if a particular party or a particular person, maybe he has left his products or goods at your shop, then a particular person or party actually comes to ask for the goods. Then you sell the goods on behalf of this person who has left the goods at your shop. Then when this particular person actually maybe arrives, he doesn't actually basically question or ask as to the reason as why you sold the products on his behalf. So according to how he conducts himself, so he hasn't basically even questioned. So it can be presumed that an agency had been created between you as a person who was holding the goods on his behalf. So by the conduct of the principal, it can be presumed that the agency has been created whereby this person has the authority or capability to be able to sell the piece of shoes on your behalf. even though when you left these particular goods, you had not given the mandate that they are supposed to be sold. But since he knows you normally sell them, he sells them on your behalf. But basically, when you arrive and realize the shoes have been sold, you don't question anything, but basically you take up the amount that was received for the price in terms of selling the shoes. So by your conduct, by taking up the amount in terms of the price without having to question, by your conduct, it can be presumed that an agency had been created between you and the person you left the pieces of shoes with. So through the doctrine of estoppel, by the conduct of the principal, it can basically be presumed an agency has been created between an agent and the principal. So through the doctrine of estoppel, as to how the principal conducts himself or carries out himself in a relationship between him and another party, it can be presumed an agency has been created through what we call the doctrine of estoppel, the doctrine of estoppel. Then we have necessity. What do you mean by necessity? An example you can actually be able to give, it can happen in two ways, either commercially or maybe domestic. So maybe we can start with domestic. Let's say, for example, there is a fire disaster in your neighbor's property. There's a fire disaster in your neighbor's property. So out of necessity, to be able to maybe save maybe his house or her house, you basically enter your neighbor's premises and you actually assist in ferrying water to be able to put out the fire. So it simply means that you had not actually been authorized or given the mandate by your neighbor. But out of necessity, basically, you've ended up having to carry out a particular task on behalf of your neighbor, putting out the fire. What is the necessity? There is a fire disaster. What is the necessity? There's a fire disaster. Out of necessity, there's an agency created between you and your neighbor and you as a person for having gone to be able to assist in putting out the fire. So out of necessity, basically an agency can be created, and we're saying it can be domestically, as to according to what I've just explained, or alternatively, it can be commercially. Let's say, for example, in this case, you basically have a big go down with products, maybe along Mombasa Road. So you've stored these particular products of yours in that particular go down. Then it happens that you've actually employed a security man to be able to guard this particular go down. So what will happen in this case? Let's say, for example, you don't stay there, but you have given the authority to the security man to be able to safeguard the goods. Then it happens that, for example, a fire disaster happens at the go down. So in this case, this security man doesn't have any way he can be able to reach out to you to be able to give out instructions as to what can be done after having realized there's a fire disaster at the go down. So out of necessity, given that this particular security man cannot actually be able to reach out to you, so what he does, basically, he opens the go down or breaks the door for the go down and starts to salvage these particular products of yours so that they are not actually destroyed by fire. So remember, in this case, we are saying that this security man doesn't have the capacity or capability to be able to reach out to you to be able to give instructions. Probably, maybe if he is able to reach out to you, basically you can be able to give the instructions, just leave the products to be destroyed by fire. So don't waste your time having to salvage or save them. So out of necessity, that given that he's not actually able to reach out to you as the security man, he basically opens this particular go down and salvages the products or goods on your behalf. So out of necessity, what we call commercial agency of necessity, then it can be taken that this particular security man decided to basically take up the goods or protect the goods on your behalf, and there were no instructions to be given to him as to what is actually supposed to be done. So it can basically be commercially or maybe domestically, as I have just explained. And then we have the last one, which is actually cohabitation. So what do you mean by cohabitation? This is whereby it is basically presumed that by law, where a man and woman are living together in circumstances in which they portray themselves to be like a husband and a wife. So it can simply be presumed that this particular wife can be able to act as an agent of the husband, can actually be able to act as an agent of the husband through cohabitation. By cohabitation, by cohabitation or by presumption, the wife is taken to act as an agent of the husband, and therefore, in this case, this particular wife can be able to undertake or maybe acquire like goods like necessaries or necessities on behalf of the husband. So what we mean by necessities are basically things that these particular parties cannot actually be able to do without. In this case, we are talking about, let's say, for example, food, shelter, or maybe clothing. So it is normally, it can be presumed under the law that the wife was actually acting on behalf of the husband in pledging for his credit. What we mean by this, going basically to the shop and getting goods or products on credit, and therefore giving the assurance that the husband or the man will actually be able to pay, So that's what we mean by agency by cohabitation. Remember, we are saying that they must be staying together as a husband and wife. They must be staying together as a husband and wife. So it doesn't mean that for example, in this case, if it is a girlfriend and a boyfriend, so maybe they just visit each other once in a while, so that is not cohabitation. So the girlfriend in this case shouldn't take advantage and pledge the security or credit of the boyfriend, such that he's taking products or goods on credit at the nearby shop by pledging that the boyfriend will actually pay. So since they are not staying together, they just visit each other, and then they are not cohabiting. So therefore, the girlfriend cannot actually basically pledge the security of the boyfriend. Remember, we've said the term is cohabitation as what? Husband and wife. So that must actually basically be proved. And it must be a domestic establishment. What do you mean by a domestic establishment? I know that you've taken a room at basically, let's say, for example, Hilton Hotel. So that's where basically you are staying. So that is not actually basically a domestic establishment. So that is basically like out of a domestic establishment. So it must be a domestic establishment, cohabitation in a domestic establishment. So if that one is actually able to be proved, then it can actually basically be concluded that these particular two persons are basically staying or living together as a husband and wife,
In progress.
Unmute yourself. Kindly unmute.
So I just want you to see what I've just shared there. So what we mean by cohabitation. So maybe you can have Mary. So Mary can just go through the first two paragraphs. So the first two paragraphs of agency by cohabitation. So Mary, are you there?
Yes.
Yes, you can just take us through agency by cohabitation.
This is another category of agency presumed by law. It is presumed where a man and a woman are living together in circumstances which portray them as husband and wife. The woman is presumed to be an agent and can pledge the man's credit for necessaries. Marriage is not essential for the agents to arise.
Let's just continue.
However, the following conditions are necessary. Cohabitation. The two persons must be living together as husband and wife. It was so held in Joel versus Res. Domestic establishment. The persons living together in a domestic establishment in the presumption of agency to arise in Deban Menen, where the parties were cohabiting in a hotel. It was held that the presumption of agency could not arise and the woman was liable. Number 3, necessaries. The woman's authority is restricted to pledging a man's credit for necessaries.
Yes. So what they mean by necessaries, they are, just I've told you, they are basically essentials. So things you can't do without, like let's say, for example, food, clothing, maybe shelter. So, for example, taking up a house and basically pledging that the husband will likely be able to pay. So if they are necessaries, then the wife can be able to act, the woman can be able to act as an agent. And it must be, this person must be cohabiting in a domestic establishment, not like in a hotel. Then that particular term, cohabitation, is very important. They are living together, they are staying together, they are cohabiting. So they are cohabiting. So, so that is basically what we mean by so I want us to basically get agency by ratification. So that one might be a bit confusing. So this one we can have Boaz. Boaz, are you there?
Yes.
Yes, you can take us through agency by ratification.
Ratification, this is the adoption or confirmation by a party of a contract previously entered into by another purporting to do so on his behalf. Agency by ratification arises after the agent has acted. It comes into existence when the person on whose behalf the agent purported to act and without whose authority he acted adopts the transaction, as if there had been prior authorization. By ratifying the transaction, the agent's authority is backdated to the date of the transaction. Ratification by the principal creates the agency relationship, validates the transaction entered into by the agent, relieves the agent from any personal liability.
Yes, it relieves the agent from any personal liability. So basically, you can be able to see what is coming out. That this agent or this person had already done the act. So what you do later on as the principal, you just come to approve. Once you approve, now the agency is created. So that's what they are saying. Basically, it happens after already the agent has acted. So once now that particular ratification or approval has been done is when now the agency is created. But if it is not actually approved, then it simply means that the agency has not actually been created. So, so the following conditions are actually usually very necessary. So sometimes they have tested this in the exam. So the following conditions are usually very necessary for agency by ratification to be able to arise. So the agent must have purported to act on behalf of the principal. So according to how he was carrying out himself, basically he must basically be taken to have be purported to basically to be that he was actually acting on behalf of the principal. The agent must have had a competent principal. So there was a natural or juristic person who could have become the principal. The principal must have had capacity to enter into the transaction when the agent did, as well as when he ratified it. So this particular person we are calling the principal must be having the authority to be able to approve. Because without that authority, it simply means that he cannot actually be able to ratify or approve. So without that authority, the agency won't actually be created. The transaction entered into by the agent must be capable of ratification. It must not have been illegal or void. So an illegal basically transaction, it simply means that it goes against the elements or basically requirements of a valid contract. So if it is an illegal contract, then even if it is ratified, it cannot actually basically be taken as being an agency contract. So the principal must ratify the transaction within a reasonable time, so not having to wait for a very long period of time. The principal must have been aware of the material facts affecting the transaction. the principal must ratify the contract in its entirety, not actually basically like half of it, or maybe bit of it, or half of just have to ratify the entire contract or agreement, So maybe you can go through by estoppel. So by estoppel. So this one we can have Mercy. Mercy, take us through agency by estoppel. Is Mercy there? Or maybe we can have Sasha. You can have Sasha. Agency by estoppel. Or Ruth. Ruth, you can take us through agency by estoppel. Ruth.
This agency is created by the equitable doctrine of estoppel. It arises where a party by word or conduct represents other third parties as his agent, and the third parties deal with the agents. The other party is estoppel from denying the apparent agency. Agency by estoppel arises in circumstances. Number one, where the parties have no relationship, but one of them represents the other as agent, and third parties rely upon the representation. Second, where the agency relationship exists between the parties, but the principal represents the agent as having more authority. Requirements for agency by estoppel. The condition necessary were laid down in Rama's case must exist. 1. A representation by word or conduct intended to be acted upon. 2. Reliance upon the representation by the representer. 3. Change in legal position as a result of the reliance. 4. It would be unfair not to stop the representer.
So you can just go up to that particular point. So that's basically what we mean by agency by estoppel. So whereby a person, as to how he conducts himself, it can be taken that basically is acting on behalf of another party. So if that particular other party basically does not deny that that particular person was acting on his behalf, then it can be simply be taken that an agency has been created through what we call the doctrine of estoppel. So how he conducts himself, how that agent or person calling himself an agent is conducting himself, it can be presumed that he's acting on behalf of another party. So if the other party doesn't deny, or basically it's like he has already approved the acts of the agent, then it can be taken that basically an agency has been created through what we call the doctrine of estoppel, through the doctrine of estoppel. So that is how basically agency can actually be created, how agency can actually be created. So I want us to look at the duties of the parties under an agency contract. So remember, you said there are two parties. So you have the principal and we have the agent. You have the principal and we have the agent. So what are the duties of the parties? So what are the duties of the parties under an agency contract? So we can start with let's say start with the agents. Can start with the agents. So the duties of the agents. What are the duties of the agents under a contract of agency? What are the duties of the agents under a contract of agency? So number one is duty to perform his obligation, duty to perform his obligations, 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 duty to obey, you can be able to say duty to obey the principal instructions, duty to obey the principal's instructions, the principal's instructions. So duty to obey the principal's instructions. So the principal will be able to give out certain instructions which must actually basically be obeyed by this particular person we are calling the agent. Another one is duty to respect. Duty to respect the principal's title. The principal's title. Duty to respect the principal's title. The principal's title. The principal title to the property. To the property. To the property. To the property, you can be able to say to the property held, to the property held on his behalf, to the property held on his behalf, not to change the ownership. Not to change the owner. For example, if you are selling products on behalf of BDCO as a company, so you must not actually change on the way and say that the products belongs to you. So basically, you must represent the products as the products of BDCO as a company, or BDCO as a company. Another one is duty to account for all the monies held on behalf of the principal. Duty to account for all the monies, held on behalf of the principal, due to account for all the monies held on behalf of the principal. So in this case, you are selling, you are moving around as a sales agent. While you sell, you get money. So you must actually be able to account for all this money once the principal wants to know what actually happened. Duty to exhibit what we call a degree of care and skill. Duty to exhibit a degree of care and skill. Duty to exhibit a degree of care and skill. Duty to exhibit a degree of care and skill. A degree of care and skill appropriate to the circumstances. 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 So you must be able to carry out yourself with what we call care and skill expected of a person, maybe such as your capacity. For example, in your sales agent, so there are certain basically skills that are expected, or basically as to how you're supposed to carry out yourself. When you basically approach, for example, the customer. So how do you handle the customer? Handle the customer with what we call care and skill. Care and skill, even as you answer the questions that are basically brought up by the customer. You handle them with what we call care and skill expected of a person of such as a thinking capacity of yours. So in such a case, you must actually go to ensure you carry out yourself with what we call care and skill. Duty not to delegate. Duty not to delegate. So duty not to delegate. Duty not to delegate. I call it non-delegation. So you must not actually basically give out the task that you've been given by the principal to other parties or other persons to carry out on your behalf, because the role was given to you as the agent, so you must not actually delegate. Although under certain special circumstances, you can be able to delegate. For example, if you need expertise advice, then you'll be forced to delegate part of the work that you've been given. Or for example, if you've been authorized under the law to be able to delegate, you can be able to delegate as an agent. Or for example, in this case, in case of emergency, so you can be able to delegate part of the work. So an emergency has arisen, so you have no option, but you have just basically to call in other parties to be able to assist you to carry out the task you're supposed to carry on behalf of the principal. For example, if it is basically authorized under the contracts with the principal, for example, if the principal is authorized under the contract that you can be able to delegate part of the work, then you can simply go ahead and actually be able to delegate. So even though we are saying that you must not actually delegate as an agent or give your work to other parties, under certain special circumstances, you can actually be forced, or basically you will have no option but simply to delegate, And then another key thing, duty, is that duty of what we call confidentiality, duty of confidentiality. Duty of confidentiality. So ensure that you basically carry out yourself with a lot of secrecy or confidence. Not just to give out any information anyhowly about the principal without his authorization. So there's what we call duty of confidentiality. Then another key duty is to keep the principal always informed. So we've said number 7, duty of confidentiality. Number 8, duty to keep the principal informed. So you must ensure that you as an agent, you are basically informing the principal of all the happenings during your work as an agent, maybe by giving out reports each and every time, So those are part of the duties of the person we are calling an agent, So what about the principal? So what are the duties of the principal? What are the duties of Safaricom as a company? So what are the duties of Safaricom as a company? So duties of the principal. So duty number 1, which is very important, duty to remunerate the agent for the work done. So duty to remunerate the agent for the work done. Duty to remunerate the agent for the work done. Duty to remunerate the agent for the work done. But of course, in this case, sometimes the principal might be able to withhold the remuneration in case, for example, if this agent of his actually acted negligently without any duty of care in carrying out his work as an agent, or probably maybe he has disappeared with his property. So why should you pay someone who has disappeared with the property? So if basically has breached the terms of the contract, he can withhold the remuneration. So he's actually basically not going to pay. For example, in this case, if he discovers that this particular person we are calling the agent has basically been using his role as an agent to make what we call secret profits. So he has other side deals, which basically is making his own secret profits by using the properties of the principal, or maybe the goods of the principal. So if secret profits are being made which are not being revealed, then you can end up basically having to withhold this what you are calling remuneration. Another duty is duty to compensate. Duty to compensate. Duty to compensate. Duty to compensate the agent for any loss incurred. For any loss incurred, duty to compensate the agent for any loss incurred. For any loss incurred, duty to compensate the agent for any loss incurred while carrying out his work as an agent. 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 So those are basically the duties, key duties of the principal. Key duties of the principal. Key duties of the principal. The key duties of the principal. So we can be able to look at now the rights. So the rights of the parties. So we can look at the rights of it. So say the last one is duty to compensate the agent for any loss incurred while carrying out his work as an agent. So what are the rights of the parties? So the rights of the parties. The rights of the parties. What are the rights of the parties? What are the rights of the parties? So rights of the parties. So what are the rights of the party? So right number one, so we can be able to look at right number one in terms of, we can start with rights of the principal, rights of the principal. So the rights of the principal. So right number one that is there, so the right that he has, he has a right to dismiss the agent for misconduct. In case of misconduct, so right to dismiss the agents, right to dismiss the agent in case of any misconduct, in case of any misconduct. So right to dismiss the agent in case of any misconduct, in case of any misconduct. And then another right that he has is right to sue, right to sue for recovery, right to sue for recovery of any losses, or damages caused by the agent, damages caused by the agents. Caused by the agent. So caused by the agent. Also any damages caused by the agent, then he can actually be able to sue. He can actually be able to sue. So we can now look at the rights of rights of now the agent, rights of the agent, rights of the agent. Rights of the agent. So right to sue the principal in case he fails to pay the remuneration. So right to sue the principal. So right to sue the principal if he fails to pay the remuneration. So if he fails to pay the remuneration, he can be able to sue that particular principle. So right number 2, right of lien or to withhold the goods in possession. So right of lien or withhold the goods or withhold the goods in possession, the goods in possession or withhold the goods in possession or withhold the goods in possession, the goods in possession, withhold the goods in possession as a security, as a security, as a security for any amount owed by the principal. Any amount owed by the principal. So you can be able to withhold the goods or exercise what you call the right of lien over the goods. So withhold the goods in possession such that this particular principal can actually be able to pay maybe the fee or the commission for the work he has done. So that is what can actually also happen. So another right that he has as an agent is right of stoppage of goods in transit. So right is almost similar to right of lien, right of stoppage of goods in transit. Stoppage of goods in transit. So right of stoppage of goods in transit. Right of stoppage in goods in transit. The last one, right to withhold the passing of a property, title to a property. Right to withhold, right to withhold the passing of a property. The passing of a property, the passing of a property, the passing of a property, right to withhold 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 the passing of a property. So right to withhold the passing of a property. So those are the rights of the agents, or what you can actually be able to do in case of default of the terms under the agreement or under the contract, default of the terms under the agreement or under the contract. So we are saying those are basically the rights of the agent. So those are the rights of the agent. Rights of the agent. Rights of the agent. So we can look at the liabilities of the parties, because ideally we are saying that under the contract of agency, so the person basically who will be held responsible, it is usually the principal. So we can look at the liability of the principal. The liability of the principal. So you must actually be able to, this point should actually sink home the liability of the principal. So there's no way basically the agent will actually be like liable for the acts he's doing. The person basically will be held responsible is basically usually the principal, unless maybe under exceptional circumstances, whereby, let's say, for example, if this particular agent has acted beyond the authority or mandate given by the principal, or out of the duties or mandates given by the principal. So as a general rule, what you need to be able to know is that the principal will likely always be liable for the breaches or wrongs committed or basically done by the agent within the scope of the duties or mandates or authority given to the agent. So if he acts within those particular mandates and he commits a particular wrong, so the person who's supposed to be liable is usually the principal and not the agent, because this agent is actually basically simply acting under the instructions of the principal. Is actually simply acting under the instructions of the principal. So that is very important, and you should actually be able to understand that. You should actually be able to understand that. So maybe we can be able to have a look at this. So we can have Lenny. So Lenny, you can just take us through that particular place, liability of the principal. So I want you basically to understand the fact that always it is the principal is normally held responsible unless under exceptional circumstances. So you can actually basically take us through those two paragraphs. So just the first two paragraphs. Lenny, are you there? Lenny.
Liability of the principal.
Yes.
As a general rule, the principal is liable for breaches of contract and torts committed by the agent within the scope of his authority. The principal may also be held liable for crimes committed by the agent in circumstances such as, e.g., crimes of strict liability, where the principal uses the agent to commit crimes. In agency relationships, the principal may be named, disclosed, or undisclosed. A principal is named if his identity is disclosed to the third party. He is disclosed if his existence is made known to the third party. He is undisclosed if his existence is not made known to the third party. As a general rule.
Yes, so I can just go up to that particular point. So that is basically what I wanted you to be able to know, that so they have even given examples where they are saying crimes of strict liability. So I hope you can be able to remember what we learned about strict liability under the law of torts. So this is where basically we are talking about an independent contractor, who are basically been contracted by maybe a neighbor to construct an underground tank. Then there's an accumulation of something which actually basically escapes. So this is a case you can see that independent contractor is not actually responsible or liable. So under strict liability is one of the circumstances under which the principal will actually always be held responsible, So I want to go straight to the liability of the agent, because there's something I want you to be able to come out. Under what circumstances can now the agent be held responsible? Because you are saying as a general rule, what you need to be able to know is that the principal will always be held responsible for the wrongs done by the agent. But of course, under certain circumstances, the agent atabeba msalaba wake. Under what circumstances? So then you can just take us through the personal liability of the agent.
The personal liability of the agent. Though the principal is generally liable for the acts of the agent, in certain circumstances, the agent is personally liable. These are the exemptions to the general rule. 1. Where the agent expressly or impliedly consents to personal liability. Where the agent negligibly or recklessly fails to indicate the agency. Where the agent executes a deed in its own name. Where the agent represents himself as a principal. Where the agent exceeds his authority. Where the principal does not exist nor has no capacity, as were the case in Kellner versus Baxter. Where an agent executes a deed in the principal's absence in circumstances in which his appointment was not by deed.
Yes, so those are the circumstances under which basically now sasa tunasema the agent atabeba msalaba wake. So in this case, he will be held personally responsible. So you can be able to see, for example, whereby he personally actually basically like impliedly or agrees that is personally liable and not the principal. So where the agent negligently or recklessly fails to indicate the agency. So he's entering into a contract or an agreement with third parties, but he doesn't indicate he's doing it on behalf of maybe a company or a corporate entity that he actually represents. In such a case, if he doesn't mention such in that particular agreement with a third party, then in this case, basically he'll be held personally responsible and not the principal. So where the agent executes a deed in his own name, where the agent represents himself as the principal, where the agent exceeds his authority. What we mean by this, you act beyond the mandate or powers given to you by the principal. So there are those duties or instructions given, but you act beyond them. So you're not acting within the confines that have been given in terms of what you're supposed to do as an agent. So if you go beyond those authority or mandates given, then it simply means that you'll be held personally responsible. You'll actually be held personally responsible. So where the principal does not exist, nor has the capacity to be able to act as the principal, as in the case of what we call Kellner versus Baxter. Kellner versus Baxter. So that is very important. The circumstances under which the agent can now personally be held responsible and not actually the principal. What you are saying, as a general rule, the principal will actually always be held responsible for the wrongs done or committed by the agent, because the agent is simply acting under his or her instructions or the duties given or the acts given that are supposed to be done by him as an agent on behalf of the principal, So that is basically what you need to be able to understand in terms of the liabilities of the parties, of the parties. So I want us to look at the termination of a contract of agency. So how is it actually terminated? How does it actually come to an end? How is it actually terminated? How does it actually come to an end? Termination of a contract of agency. Termination of a contract of agency. Termination of a contract of agency. So by agreement, so number one, we have by agreement. So by agreement, number two, you can say death of either party, death of either party, death of either party. Number three, by performance, So through performance, you can also be able to talk about lapse of time, lapse of time. Lapse of time, you can talk about withdrawal of consent by either parties. Withdrawal of consent by either parties. So withdrawal of consent by either parties, insanity of one of the parties, insanity of one of the parties. So insanity of one of the parties. Can we talk about bankruptcy of the principal? If the principal has been declared to be bankrupt, bankruptcy of the principal, bankruptcy of the principal, bankruptcy of the principal. By frustration is also another way of how this contract can be terminated or can come to an end. So by frustration, by frustration. By frustration, also, for example, we've talked about a contract being created through what we call cohabitation. Cohabitation. So cessation of cohabitation. You can talk about cessation, whereby the husband and the wife cease to cohabit. Cessation of cohabitation. Cessation of cohabitation. Cessation of cohabitation. You can also be able to talk about cessation of an emergency. For example, out of necessity, cessation of an emergency. Cessation of an emergency. So these are some of the ways through which this particular contract will be terminated or basically will come to an end. So by agreement, you can just agree that we no longer want to continue to work as an agent and the principal. So through an agreement, you sign an agreement, you agree as parties, you terminate or end the contracts. You end the contract through what we call agreement. Death of either parties, so maybe the principal maybe is no longer there, or maybe the agent is no longer there. So which kind of agreement will be there? Because one of the parties is not there, then the contract will be terminated or come to an end. By performance, for example, if each and every party has already fulfilled his obligation under the contract, automatically the contract basically will have come to an end. So by performance, lapse of time, for example, if it was basically for like maybe just a period of 2 years or maybe 2 months, so once the period has elapsed, the contract comes to an end. The contract basically will come to an end. So withdrawal of consent by either parties. So if one of the parties actually withdraws from the contract or basically withdraws consent that is not actually able maybe to perform under the contract, then the contract will be terminated. Insanity of one of the parties. For example, if one of the parties has been declared to be insane or of unsound minds, that his thinking capacity is not proper. So it simply means that that is a vitiating factor. So remember, we said that some of the vitiating factors is, for example, if someone has been declared to be insane, then his thinking capacity is not proper. So therefore, he's not actually able, doesn't have the capacity or capability to enter into an agency contract. Bankruptcy of the principal. For example, in this case, for example, if Safaricom is declared to be bankrupt, it simply means that this particular company is going to be taken up by receivers, and probably it can be liquidated or its life can come to an end. So you as an Mpesa agent, so who are you working with? The company that is no longer in existence, having been declared to be bankrupt, not actually able to meet its obligations. It can be taken up by the creditors and eventually be wound up. So there won't be that principle as Safaricom to work with the agent. So automatically the contract comes to an end. By frustration, certain factors which are actually beyond the control of the parties, so which cannot actually basically be controlled by the parties. So you have no option, and therefore, in this case, the contract will come to an end. The contract will come to an end. We can be able to talk about cessation of cohabitation. I think I've explained. We've said one of the ways through which a contract of agency can be created through what we call cohabitation. So if the husband and the wife are no longer actually cohabiting, so automatically the contract by cohabitation will simply come to an end. So cessation of an emergency, for example, if it is a contract created through what we call necessity. So out of an emergency, out of necessity, the contract was actually created, but now the disaster or the emergency has ceased, is no longer in existence. So the agency will automatically come to an end. So someone is asking whether by breach, So maybe by breach, it will lead to other things. For example, now through an agreement, since one of the parties has breached, then you can agree that you terminate the contract. But of course, if there's breach, then there are several options. So either to take this particular party to the courts, or maybe to decide that you terminate it through what we call maybe other ways among these ones, let's say, for example, by agreement. Or maybe by going to the court and asking the party, the court asks the party to perform his obligations under the contract, So those are the ways through which a contract of agency can actually be terminated, So that's all about the contract of agency, And I think next time we'll be looking at the contract of insurance, the contract of insurance. We'll be looking at the contract of insurance. So unless there's a question about agency, maybe you can probably ask, but that is quite enough under the contract of agency, So I think if there's no question, then probably we'll meet next time, and I think we'll look at the contract of insurance, contract of insurance.